this case, dealing with the can we expel everyone from the home case. So this is Jessica Barron, Kenneth Kenneth Wiley, and William Campbell versus the city of Granite City, Illinois. This civil rights lawsuit challenges a Granite City ordinance that forces private landlords to evict law abiding tenants as a punishment for other people's crimes. Plaintiffs Jessica Barron and Kenneth Kenny Wiley have lived in their homes for the last 2 years. They intend to purchase the homes for themselves and their 3 teenage children. Each month, they make payments towards the purchase price for the current owner. This arrangement is known as a real estate installment contract, and it's common for people who don't qualify for traditional mortgage. So this is rent to own in the context of real estate. Fair enough. So it's not a mortgage and it's not just a rent, it's rent to own. Fine. Jessica, Kenny, and Bill are all satisfied with this arrangement, but Granite City is trying to coerce Bill into declaring the contract void and evicting Jessica and Kenny's family from their home. Over the past month and a half, Granite City police have repeatedly called Bill to insist that Jessica and Kenny have to go. On one occasion, an officer confronted Jessica at City Hall and declared that he was personally evicting her. Ooh. That same officer threatened to arrest Bill for not commencing an eviction suit. No. On 2 occasions, officers have even pounded on the door to serve compulsory eviction demands. Well, as to that last part, that might be legitimate. I don't know about the nature of the demands, but pounding on someone's door to serve them a legal notice, that's perfectly reasonable. Their part's not so much. The basis for the city's campaign is not that Jessica and Kenny have done anything wrong. It is that a friend of their 16-year-old son broke into a restaurant elsewhere in town. Because the friend often spent time at Jessica and Kenny's home, the city invoked its compulsory eviction law and demanded that Bill evict Jessica, Kenny, and their children. So see what we got here going on, kids? We got parents and their kid, their kid has a friend, their friend broke into a restaurant, and somehow we want to kick the entire family out of the home because their son's friend broke into a restaurant. That strikes me as a little over the top at minimum. Under the law, the city coerces private landlords to evict entire families if any member of the household, or even a guest, comprises a crime anywhere within the city limits or sometimes anywhere at all. It is no defense that Tenef has nothing to do with the crime. Here, in fact, the police caught the restaurant burglar only after Jessica discovered them in the home, alerted the police, and helped the officers to arrest them. Let us read that again, because I think that's a point worth mentioning. Here, in fact, police caught the restaurant burglar only after Jessica discovered him in her home, alerted the police, and helped the officers to arrest him. This is no good deed goes unpunished on steroids. The homeowner was aware of this restaurant thief in their home. So what they do? They called the police and said, "Hey, there's a thief in my home. Maybe you want to do something about that." And the police, rather than saying, "Hey, thanks, for giving us a tip," they said, "We want to kick you all out of your home." Just from a straight policy standpoint, this does not strike me as a good idea. We might want, as a society, people to call the police and say, "Hey, I'm aware of people who've committed the crimes, and maybe you'd like to do something about this." I think this is behavior we'd want to encourage. We wouldn't want to say, "Thanks for tipping, by the way, we want to kick you out of your house." This may, in some ways, discourage people from cooperating with the police in the future. Even so, the city wants Jessica gone, and Kenny gone, and their children gone because of someone else's misdeed. This effort to make an innocent family homeless violates the federal constitution at bedrock level, and for this reason, plaintiffs seek relief in this court. Every once in a while, actually, it's not that infrequent as a lawyer that I have this problem, but every once in a while, I get a client, and As a good lawyer, I want to figure out why my opponent thinks the way they do. I want to figure out their motivations in life. I want to figure out what they want because hey, maybe I can give it to them, right? They might be suing over one thing, but what they really want is something else. So it pays to figure out what's going on and what's really going on because sometimes you can do that. So it is beneficial for me to put myself in the mind space of my client's opponent because I'd like to be able to figure out what's going through their head. And sometimes I'm like, for the life of me, I cannot figure out from your point of view why you want to do this. What is going on in your mind? And this is a case that strikes me as this. It's like at no point did the city look at themselves and say, hey, maybe we should not do this. Maybe this is a bad idea. Maybe this law is generally a good idea, although I question that deeply, but maybe it's generally a good idea. But maybe in this specific situation, we should just say, this is just stupid. Maybe we should not do this. Is this a thought that anyone ever had at any point? Apparently not, because we're here. I mean, some people will just double down to the end of time, even though it's like it would just be much easier to say we made a mistake and we're stupid. And as the city's attorney, I'd probably be saying to my client, you're being an idiot, right? Anyways, jurisdiction, venue, blah, 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 parties, blah, blah, blah. All right. Factual allegations. Under its compulsory eviction law, Granite City uses the threat of governmental sanctions to coerce private landlords to evict tenants who have done nothing wrong. He's guilty if I say he's guilty. Granite's compulsory eviction law. In 2013, the St. Louis Business Journal asked Brian Kozin to identify the most controversial issue you've worked on during the many years as a city attorney. His answer, the crime-free housing program. I can see why. Benign in label, which is always a good reason to look past the labels. Who could oppose the Anti-Terrorism Act? Oh, look what it actually says. Oh, okay, yeah. So it's always pays to look past the label. Benign in its label, the Granite City crime-free housing program is deeply unconstitutional practice. In truth, it is a compulsory eviction law. Under it, the city can and does coerce private landlords to evict entire families from their home based on the crime committed by other people at other places. Yeah. First enacted in 2006, Granite City's compulsory eviction law applies to all rental properties within the limits. The law applies also to property that are subject to contract for deed, such as the installment contract, which we'll call rent to own. The compulsory eviction law is not limited in application to public housing. Yet public housing has its own sets of problems with this, and the rationales and philosophies get a little tricky for a lot of obvious reasons. If you are the city providing housing to someone and there's drugs going on in the housing project, obviously that decreases that raises real problems. You as a city are well incentivized to keep drugs out of your housing projects. Reasonable, right? But if the son of a mother is a drug dealer, then you might have to say, well, you can't have that son in here, which is a practical matter means you're evicting the mother, which is not a good thing, but it may be necessary to keep the place drug free. But it's an obvious problem where you have these competing issues. You want to keep it drug free, but you want to supply things to people who are, in a bad place. So it's tricky. But this is private, so all those implications don't matter because the philosophical complications don't apply. This is private, not public, so you don't have those complications. You can rent. You should be able to rent to pretty much anyone you want, right? The compulsory eviction law applies to private landlords renting private property to private tenants who pay with private income. Private. Yeah, the rationales are different. Landlords are subject to governmental sanctions if they violate the law. So this landlord is really going to bat for these people, and good for him. The governmental sanctions include monetary fines and suspension or revocation of the business license. That's pretty harsh. Among the violations that can give rise to sanctions are the following. The failure of the licensed lessor, we'll just say the lessor, the failure of the lessor to take prompt, diligent, and lawful steps to remove lessees from the property of the rental unit, following notice of commission of a felony in the rental unit, following notice of 4 ordinance violations in the rental unit, or following notice of a violation of crime-free house lease addendum, Exhibit B. I'm guessing Exhibit B has quite a lot to say. The addendum referenced prescribes all manners of criminal offenses. Yeah. Prescribed in Addendum B is where all the magic is happening. The addendum reference prescribes all manner of criminal offenses committed by tenants, members of the households, or guests, not just on the rental property, but elsewhere too. For example, the addendum provides the lessee or any member of the lessee's household shall not engage in criminal activity, including drug-related activity, within the city limits. The lessee shall not engage in any act intended to facilitate criminal activity, including drug-related criminal activity. Facilitation can get pretty broad sometimes, so that's stronger than it might initially read. The lessee cannot engage in criminal activity found to be equivalent to a forcible felony. Oh, equivalent to. Engage in any criminal activity found to be equivalent to a forcible felony. Here's a question. What is equivalent to a forcible felony that's not a forcible felony? Isn't the very fact that it's not a forcible felony by definition mean that it's not equivalent? The very fact that you have a category called forcible felony means that everything that is not in that category is definitionally non-equivalent. That's the nature of equivalence. So what the hell does that even mean? Criminal activity found to be equivalent to. What the hell is that? I'm guessing the city thinks it means all the things. Incidentally, while I'm thinking about it, this is also a problem as it relates to gun control, because you'll see politicians say things like, let's ban AR-15s and all substantially equivalent firearms. Yeah, the nature of what substantially equivalent is matters quite a lot when we're debating these kinds of things. Moreover, it's Granite City's policy and practice to expand these addendums even further. The addendum provides that neither the lessee nor members of the household shall engage in any act to facilitate. But in compulsory eviction demands, the city has also asserted it's enough for the guests to engage in such an act. Who is and who's not a member of a household can get obviously legally tricky too. Yeah. Particularly in the case of an overnight guest. Because if you're interested for Fourth Amendment purposes, if you are a guest in someone else's home, you do not have Fourth Amendment rights unless you are an overnight guest. If you're an overnight guest in someone else's home, you do have Fourth Amendment rights. So if the police come and bust down the home door and you have drugs on you, sucks to be you, unless you're an overnight guest, in which case you might have an argument because you're an overnight guest. So here's the $64,000 question. If you're an overnight guest, do you count as a member of the household or not? I don't know. I bet the city says yes. The addendum is not a lease addendum as most people would understand the phrase, nor as I would understand the phrase. Neither landlord nor tenants are free to negotiate or opt out of the addendum. That's exactly right. It's not a lease addendum. It's not an addendum to the lease because it's not part of the contract. Because no one negotiated it. Rather, the city mandates that landlords and tenants sign the documents as a condition of receiving occupancy permits. Fun. Even if that's an empty act, if no one were to sign it, the addendum would still apply. By law, every agreement for lease of residential lease shall cooperate with the lease and deemed to include all terms of the lease addendum. Nice. What does overnight mean? For practical purposes, are you sleeping there? Yeah. Are you sleeping there? Do you go to bed at some point and wake up at some other point? That would qualify. Do they give you a room or a sofa, or did they designate you any space that is for you and say this is your bed for the night, this is your couch for the night? Is there a space that is yours for the evening for you to sleep on? That would qualify. It also helps substantially if you have a door, but that may not be strictly necessary. Nor are landlords and tenants automatically deemed to have acquiesced to the landlord addendum, but landlords are required by law to enforce the addendum. As explained above, a landlord is required by law to take prompt and diligent steps. The end result of this law is that landlords are required by law to evict entire families when the city claims any member of the tenant's household engaged in criminal activity anywhere in the city, engaged in any attack to facilitate, which again can get pretty dicey, or committed a forcible felony or something substantially equivalent to that, whatever that means, anywhere. If the city demands a landlord evict a lessee under the compulsory eviction law, the landlord does not have the discretion to forego eviction because the lessee was innocent of any wrongdoing. Jail cell at a police station does not qualify as an overnight guest. You do not have a right of privacy in a jail cell. Yeah, no. But no. If you break in, that also does not qualify. You have to be there at the invitation of the person who is the landlord. If you break in and manage to secure a space for the night, that does not qualify you as an overnight guest because you're not a guest because you're trespassing. What kind of question is this? The jail cell. Who's thinking that a jail cell qualifies? Of course it doesn't qualify. No. Oh man. If the city demands a landlord evict a lessee under the statute, the landlord does not have discretion. If the city demands a landlord evict under the discretion, does not have discretion to forego because the lessee was not involved. Does not have discretion to forego because the lessee was unaware of the activity. The landlord does not have discretion to forego because it took place at a place other than the rental property. Yeah, maybe I just don't care if you commit crimes. I'm a private person. I'm not required to care. Your business is your business. If you're committing crimes, I don't care. Just don't bring it into my house, right? If you're a drug dealer, as long as you don't bring the drugs into my house, I don't care. That's a possible attitude you could have. And incidentally, if you get arrested, you still owe me money. Where the city claims a predicate crime has taken place under the law, the landlord has no choice but to evict the entire family. Nothing in the law prevents the same landlord from renting any other property to the same evicted tenants. That's a nice trick. So you can rent them a different property, just not the same property. That's just beautiful. Nor does the law prevent any other landlord from renting the property to any other tenant. Yeah. Before Granite City may take an action to revoke the business license, the ordinance provides that certain procedures shall be followed. Yes, what we would call due process. Granite must serve upon both the landlord and tenant a notice containing the following information: a copy of the law, the address of the building and zone administrator, and facts alleging ground for revocation. All you see is Fourth and Eighth Amendment violations. I don't know about Eighth, but I definitely see Fourth Amendment violations for sure. And Fifth, because of the property interest. Taking away someone's property, having a lease qualifies as a property interest. So it's the government taking away a property interest, so it's a Fifth Amendment violation too. Upon receipt of this information, either landlord or lessee may file a written grievance. I have many written grievances. If the landlord invokes the grievance process, they're required to schedule a hearing. Yes. At the hearing officer's decision shall be limited to the question of whether the landlord must begin eviction proceedings. Okay, that is the question. I'm not sure what other questions you want to discuss. Yeah, that makes sense. What other questions are there? I mean, for the hearing officers, the underlying legality of the law is not a question for the hearing officer. It's a question for a court. After hearing, the landlord must make first a showing of entitlement. Only thereafter must the city sustain the burden of justification of action. Okay. At one such hearing on information and belief, a high-ranking officer within the police department demanded a pregnant woman be evicted based on offense allegedly committed by the fiancé. The police officer on information and belief justified the city's position on the following ground: he is guilty if I say he's guilty. Good. There's no requirement that the law be proved that the lessees were complicit. There's no requirement that they prove that they were aware. And even if you're aware, that's not in and of itself illegal. I can be aware all day long that you're committing all kinds of crimes. that is of itself not a crime. My knowledge that you're committing crimes is not my problem. In fact, of more than 300 compulsory eviction demands Granite City has issued between 2014 and today, more than 100 cite crimes from shoplifting to driving with a revoked license that did not take place at a rental property. So, driving with a revoked license apparently is sufficient offense to get the entire family evicted from their home in the city of Granite City. If this is in Illinois, you know, it's wow. Jessica Barrett and Kenny Wiley were born and raised in Granite City. The city has not been so kind to them. They've been in a committed relationship for the last 18 years and they have 3 teenage children. Their 2 sons attend school here. When summer break ends, their children will return to school here. Kenny works as a forklift operator and Jessica's struggling to find work as a housekeeper. Okay, so your basic lower middle income or upper lower income family. Okay. For the past 2 years, they've lived in a modest house. Below is a copy of the house. It's modest, but, well, functional. It's definitely modest. Jessica and Kenny are in the process of buying the house under an installment contract. Who owns the property? They're both named as parties to the contract. Each but they pay an installment. This arrangement is common for people who don't qualify with a traditional mortgage. Okay. For the past 2 years, they paid monthly installments. They ultimately want to buy the property. Like Jessica and Kenny, Bill has lived in most of the area. He currently owns 15 properties. In part because he's looking to retire, many of his properties are leased on a rent-to-own basis. Yeah, makes sense. So he's looking for an income stream. Okay, great. Jessica and Kenny have an open door policy when it comes to their children's friends. Many teenagers come from troubled backgrounds, and Jessica and Kenny's view their home as a safe home for kids who have difficulties. Yeah, I mean, we can tell from this fact pattern that they're going to be in an impoverished area and with impoverished friends. And as one would typically expect, people who tend to be more wealthy don't commit as many crimes because they don't have the necessity to. So you would expect that they would, commit more crimes just from demographics. For a time, Jessica and Kenny fostered Jessica's nephew. Kenny is certified to be a foster parent. Although Jessica and Kenny do not currently foster children, it's not uncommon for teenage friends to come by for a meal or have Jessica do their laundry or spend a night. This sounds like a perfectly nice family. It sounds like a nice family. We have Jessica doing laundry for the neighbor's kids. That's cool. Why do we hate these people? Since no grand jury, the city's fucked. I mean, there's no grand jury implicated because this whole thing is non-criminal. This is a civil action, so grand juries would never be implicated. This entire thing is civil, but it's just, yeah, it makes no sense. Okay, in the fall of 2018, their eldest son befriended a guy named Jason. Jason does not have a permanent residence. Just based on this understanding, he had recently come from Missouri. At first, Jason told Jessica and Kenny that he was homeless and his mother died. Jessica and Kenny later learned that Jason's mother was alive. Like other friends, Jason sporadically spent time in their home. During that time, he'd sometimes spend the night. Overnight guest. Once it got cold out around January, Jason started spending more time. During this time, his movements remained irregular, but he'd often sleep at least a few nights at the home. At no point was he named on the contract, nor did they have any obligation to offer him shelter. Right. On information and belief, Jason broke into a restaurant. Neither Jessica nor Kenny had anything to do with the crime. At around 6 in the morning, Jessica encountered Jason in her home. She was not aware of the burglary, but she told him to leave the house because he's carrying bottles of beer. When returning from her sister's home later that day, Jessica was approached outside her home by an officer from the police department. The police officer informed Jessica that Jason was suspected of having burglarized the restaurant. This is the first they heard of burglary. The police officer asked Jessica whether he was inside the home. Jessica accurately thought that he was not. Upon entering the home, Jessica found Jason, in fact, returned. Jessica required the younger son to run down the street and alert the police officer. Okay, wow. Wow, this is just amazing fact pattern here, guys. Are you keeping up with what's going down? So the police say, hey, we think that this particular kid may have committed a robbery. Is he at your home? And she says, no, I don't think so, which is perfectly reasonable because I kicked him out. And then I come back and I find the kid is there. And then what does she do? What does she do? She leaves her home to go run down the street to find the police officer to say, hey, after all, he is at my home. For this, the city wants to expel them all. Wow. I mean, we have enough trouble getting people to cooperate with the police as it is. There's this whole idea of, you don't snitch, which incidentally I think is pretty stupid because, if you want to live in a good community, it makes logical sense to my mind that you want people who are not behaving in a good way with the community to not be part of your community. So, saying, hey, this guy over there is committing all kinds of crimes, go do something about it, seems like a perfectly reasonable thing. But if you're of a mind that says snitching is bad, this example is not going to convince you otherwise. Because not only is snitching now a betrayal of your community, snitching apparently is a way for you yourself to get evicted from your home. Unbelievable. All right. Upon entering the home minutes later, Jessica found Jason in return. Told the youngest son to run down the street. He did so, and with Jessica's consent, several police officers entered their home. Jessica led the officers in the basement and directed them to a crawl space where he was hiding. As the officers removed him from the home, one of the officers thanked Jessica and reassured him that she had done the right thing. That reassurance now seems somewhat less reassuring. On information and belief, on the day of the arrest, the state of Illinois charged him with one count of burglary, a state law felony. On information and belief, he pled guilty to the felony. On information and belief, they sentenced him to probation and ordered him released. How old was this person? That's also reasonable. Did they say how old he was for probation? 18. So he was 18. So he was legally adult, but I guess we're showing mercy today. That's fine. Just curious. If he has no prior felonies on his record, then that seems reasonable. Especially since no one was hurt, only property was taken. Probation for a first felony seems reasonable. Jason Lynch showed up at the house a couple of times after the arrest, but before even learning of the compulsory eviction demand, Jessica told him to stop coming into the home, and he stopped. Fine. On or around June the 18th, 2019, so this has all just happened. This is like 3 months ago, right? Lieutenant Mike Parson, the crime-free multi-housing officer, what a great name, came to the home, or came on a phone. They instructed Bill to evict Jessica, Kenny, and their children. Told Bill about the incident, said the entire family would just have to go. At this time, they had not served him with a compulsory eviction demand. Bill does not want to evict them. Bill thinks Granite is unjust and unconstitutional. Well, I definitely think it's unjust for sure. Thinks they have nothing to do with misconduct. They know they're good tenants. They believe evicting them would cause serious hardship for them and their children. Rather than evict them outright, he sent them a 30-day notice. Well, even if you're going to evict, you normally have to go through an eviction procedure. I would imagine that this law is not, I would hope at least, I would hope this law is not written in such a way as like I can just immediately kick them out the door. Normally when you evict someone, you have to go through an eviction procedure. So serving them with a notice would be like the way you would normally evict somebody. There's procedures for this. Rather than evict them outright, he sent them a 30-day notice. He informed Lieutenant Parkins of the demand, but acknowledged that I know how hard you work to get your payments on time, and I also suspect your intentions are good. Bill's lawyer told them to keep the property in good shape and make sure that Jason no longer comes to the house. Jessica promptly contacted Bill and confirmed the issues had been resolved. A week later, Jessica attended a hearing at City Hall. The purpose of the hearing was to address two citations. one involving overgrown grass in her yard, and the other involving an allegedly misplaced sump pump. While speaking to a city official about her grass and sump pump, Jessica was confronted by a uniformed officer. On information and belief, this officer's name is Bernard. The officer asked Jessica whether she'd been evicted. Jessica had no idea what the officer was talking about and told him as much. The officer informed Jessica that she was subject to eviction because Jason committed burglary. In response, Jessica explained she had alerted the authority to Jason's whereabouts and led the police officers to arrest him. The officers nonetheless declared that he was personally evicting Jessica, and they intended to arrest Bill Campbell for not instituting eviction proceedings. Key. A day later, the same officer knocked on the front door and served her with a notice. A true and correct copy of the notice is attached. The demand letter was sent from Lieutenant Mike Parsons and was directed to some people. The letter stated, in general terms, it is my understanding there is evidence of either commission of felony in your rental unit allowed or permitted by your lessee, or one of 4 ordinances, or blah, 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 whatever, yeah. The letter also stated, with capitalization altered, on May the 21st, 2009, officers of the Granite City Police Department responded to a burglary. The investigation led to the arrest of Jason Lynch, who resides at this particular location. Jason Lynch was charged with burglary, a Class 2 felony. Since this felony incident occurred in the city of Granite City, it is a direct violation. Is it really called the city of Granite City? Okay, fine. I just assumed they called themselves Granite City, and like all these other references to the city of Granite City was like make a kind of a legal formality, but they keep saying it. So now I'm just assuming the city is literally called City of Granite City. Okay. It is a direct violation of the Granite City Crime-Free Multi-Housing Ordinance, a violation of Crime-Free Multi-Housing Ordinance. Although the compulsory eviction demand was dated the 23rd, they didn't receive May the 23rd. They didn't receive it until June the 25th. The city did not serve them with the demand until nearly another month had passed. On July 17th, Lieutenant Parsons left Bill a voicemail insisting they move forward with evicting. Lieutenant Parsons said the following: Bill, Lieutenant Parsons with I'm going to do this in my best cop voice. Bill, Lieutenant Parsons with the Crime-Free Housing Unit, calling to find out where we are with your property at 1632 Maple. Why these people aren't being evicted yet. Let me know what I need to do, because I have to present you to the mayor to revoke your business license. I guess I'll have to do that. These people need to go. We've had the conversation. You didn't accept your letter. We'll be looking for you today. Thank you. A few hours later, Lieutenant Parkinson and 2 other officers tracked down Bill at Jessica and Kenny's home and handed him a copy of the notice. A true and correct command is attached. The compulsory demand stated that he could submit a grievance within 15 days. I've got some grievances for you. I got your grievance right here. Bill mailed a copy of the grievance to the Bill's zoning administrator on August the 1st. He also delivered a copy on August the 1st. And he decided not to wait for them to make their decision, which I have no particular objection to. Yeah, normally in state law, in federal law, you normally have to exhaust your administrative remedies before you can go to court, but that's not usually true in state law. So this is probably a timely thing. If this were a federal law issue, this would not be timely. Just FYI. Jessica and Kenny do not want to leave their home. Bill does not want to evict them, but for the compulsory eviction demand, Bill would not even be considering evicting them. Jessica and Kenny are not currently in violation of any term of their lease. And even if they were, that's a private matter. Even if they're in violation of lease, that's private. They don't have to do anything. Being evicted at the city's insistence would harm Jessica and Kenny. They do not own or rent any other property. If they're kicked out, they're not sure where they would go. They do not have the resources to immediately rent another property. They likely need to rely on charity from family to avoid rendering themselves and their children homeless. Being forced to evict Jessica and Kenny would also harm Bill. It would cost money and time to pursue the eviction, and they'd lose substantial money while the home sat vacant. Bill does not have another rental property that he could make available. And if he did, then it's really not a problem to just move from one to the other. I mean, accepting the moving costs. It's like Also, like, what does it actually mean to move in this context or evict in this context? Because I'd like to know, like, just how much of a shell game I can legally play with these people. Because here's what I would do. I am evicting you from this house, but it's okay. You can store your stuff here while you're looking for another home for the low cost of $1. And incidentally, I have another property I'm willing to rent you for $1. And you can go live there for a day. And oh, by the way, now I suddenly have this other property that's available that just happens to have your stuff in it. What are the odds? And I would love to rent you this property. Would you be interested in renting this property? See, this is where my mind as a lawyer goes, because there's apparently no prohibition against, renting another property. And once I rent them that property, well, what is the problem with me renting back the property? I evicted them. It's a private eviction. Just because I evicted you doesn't mean that I can't also now rent it back to you, right? It's a private deal. Yeah, you're in breach of the lease. I'm evicting you. Okay, you're evicted. Oh, by the way, would you now like to rent this property again? Yes, I would. Hey, that's totally legal. You could do that. It's totally legal. So me as a lawyer, I'm like, how many shell games can I play with this piss poor excuse of a town? That's what I want to know. Bill also has moral objection. Yeah, I'll be like, yes, we evicted them. We evicted them hard. You can even come watch as we evict them, and you can watch them leave, and they'll be really, really sad because they're good actors. Well, they'll be really, really sad as I evict them, and you can see, and maybe I'll even have a whip, and I'll pretend to whip them, just for like the added like slavery connotations, just to make this whole scene that I'm creating, really, really dramatic, so we can do this in real good acting fashion. So maybe I, as the landlord slave owner, will get the whip as they're leaving their house in tears. Oh no, it's leaving in tears. And then I'll rent them another property. Then I'll just rent them back the same property again. So that's what I do. Because if they want to dick with me, I'll dick with them. Bill faces an impossible choice. If he complies with Granite City's compulsory eviction demand, he puts an innocent family at risk of homelessness. If he defies, he places revocation of the rental license. In the absence of intervention from the court, the compulsory eviction law and the associated practice will cause irreparable harm. Either he'll be forced to evict, or Bill will face losing his license. Losing one home is irreparable harm. Yeah, probably is. Granite City is inflicting this irreparable harm for no legitimate reason. Expelling the home will not eliminate any nuisance or noxious use of the property. Yeah, no one else is complaining. It's just the city. Expelling Jessica and Kenny from their home will not remove the individual who committed the crime. He's already long gone. Expelling them from their home will push the family closer to homelessness without eliminating any condition that gave rise to the compulsory eviction demand. Constitutional amendment problems. 14th Amendment, due process. Yes, we got due process problems out the ass. The Due Process Clause secures against state infringement fundamental rights and liberties that are deeply rooted. Among these rights is the right of innocent people not to be punished by the government. Deep thoughts from your fellow lawyer. We should not punish innocent people. That's probably a good idea. Jessica and Kenny have a fundamental property right and a fundamental interest right in their installment contract. Yes, they do. Yes, they do. They have a fundamental right. The fact that they're leasing it is irrelevant. They have a fundamental property right in the lease. It's a contingent property right, but it's property right. No lawyer would disagree. To the extent the installment contract authorizes Bill to terminate the contract, Bill retains discretion, as with any contract, to enforce or not enforce. Yeah, exactly right. Exactly right. Just because you're a breach of the contract doesn't mean that I have to do shit about it. I have a contract with you. You're now in breach. I don't care. I'm allowed to not care. It's an option. Bill doesn't want to terminate his contract based on Jason's crime. Bill will not even considering doing so based on the city's demand. Effectively, the compulsory law requires them to that their interest in the home be extinguished. Yeah, that's a taking. The effect of extinguishing the property right in their home in these circumstances would punish Jessica and Kenny far more harshly than Jason. Yeah, that's reasonable. I mean, Jason got probation. You are extinguishing their property interest in the money they've already invested. So yeah, they probably are being punished harsher than the actual felon at this point. Jason no longer resides at this, and if it does, who cares? It's not a means of removing him from where he doesn't live. Granite City does not contend that their participants are co-conspirators. Jason and Kenny were not participants or co-conspirators. They're not being punished for anything they did, except, being generous. The city's efforts to take these homes shocks the conscience. I would agree. I would agree. It shocks the conscience. Yeah, I would definitely agree. This also violates Bill's due process rights. Yes, it does. Bill also has an interest in this. Bill has a property interest in the contract as well. So Bill's property interest is also being impacted. Oh Lord. 14th Amendment, equal protection. Equal protection requires government to treat similar individuals similarly. Ugh. The compulsory eviction law treats Jessica and Kenny differently from people who are identically situated in all respects but one. People who have a traditional mortgage rather than an installment contract. Yeah, that's a very fair point. This only applies to leases. That's a very, very fair point. The city's compulsory eviction law distinguishes between people who owe their homes in fee simple, which is a very, very fancy term for owning your home, or people who have traditional mortgages. Yeah, if you own your home fee simple, it means that you own it outright. It's also called fee simple absolute, if you want to be really pompous about it. And people who rent their homes or buy their homes under installment contract. The only reason Jessica and Kenny are required to evict because it takes the form of a lease. If they had any other property interest in the home, fee simple subject to a mortgage, a life estate, they would not be subject to the compulsory eviction law. A life estate, in case you're wondering, is a form of property right which I've literally never seen in the real world, but it does exist as a matter of law, and I guess someone must use it somewhere. But basically, it is a form of property right that extends for your life. So you could give someone a life estate basically saying, it basically prevents them from further transferring it. So say I give you a life estate in this property, means you can own it, you can do anything you want with it. You can't sell it because it's only for your life. So you own it in so much as it's yours for your life, but then it reverts back to me. You see this sometimes in wills, but I've never actually seen it in the real world. At the time of the committed offense, Jason Lynch had been staying with a family that owned their home fee simple. The city could not have enforced this law. If at the time of offense they'd been staying subject to a traditional mortgage, they could have not enforced the law. In all material respects, they're similarly situated to residents who own their home fee simple. Yeah, there's really no difference. From a policy position, it doesn't really make a policy difference. What is the difference from a policy perspective if, assuming this is a good idea, which is not, what is the difference from a policy perspective of saying it only impacts people who rent? The non-policy answer to this question, as I'm sure many of you have divined, is that this is a discrimination against poor people. And as per someone who rents their home, I'm also offended by this on a more pragmatic level. So yes, apparently this is a law designed to impact poor people. Okay. The city cannot justify this sin under any level of scrutiny because they're not based on the difference. I would tend to agree. Yeah, what is the argument, city? What is the argument for treating these people differently? I'll wait. On information and belief, the city will be unable to provide any evidence sufficient to justify the distinction. I'm having a tough time coming up with it, other than we don't like poor people, which is not a valid motivation. The city's distinction between residents who own their houses fee simple or subject to a traditional mortgage and residents who rent their homes or buy them under installment contract falls under every level of scrutiny. That's because it's not rationally related to a legitimate government interest. I agree. That is the bare minimum. Every government action has to be rational basis. And I have a tough time coming up with one other than we don't like poor people, which is not a valid reason. Second, the compulsory eviction law treats Jessica and Kenny differently from other people with the same amount of alleged responsibility, that is, none, for crimes underlying the city's eviction demand. Under the law, Bill is required to evict Jessica and Kenny because the crime occurs somewhere else. They don't have any relationship, they don't have any involvement, they don't have any responsibility, and in fact took several important steps to help the police apprehend. Oh, Lord. With respect to this crime, the basis for this law, Jessica and Kenny are similarly submitted to literally everyone else in the world, and that they have no responsibility for the crime. That's a pretty fair point. Yeah, they're similarly situated to me. This is also not my problem. Yet the law singles them out for unique and uniquely harsh treatment. If Bill were to evict Jessica and Kenny, he would be free to rent the property to literally anyone else in the world, including Jason Lynch. That's a good point, too. Good point. Oh, Lord. Jessica and Kenny are being treated worse than everyone, including Jason. They alone are prohibited from living their home. Oh, Lord. I wonder also if it would be legal to evict them and then rent the house back to myself and they can be my guests in the same home. Can I do that? Then maybe they never have to leave in the first place. I'll evict them, and then I've decided, oh, I'm not actually renting this home anymore. This is just now my home. And oh, incidentally, these are now my guests. Oh, and incidentally, they're paying me. Can I do that? Oh, man. Blah, 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 blah. Okay. Third, this law treats Bill Campbell differently from every other landlord. The compulsory eviction law requires Bill to evict them from their home. Immediately upon conviction, any other landlord and any other property be free to rent. So this whole law is stupid in every possible way. It doesn't do anything it's intended to do. Bad law. Indeed, Jessica and Kenny would be eligible to rent a different home. If, for example, he also owns 1634 Maple Street, he could apply the terms by simply moving them next door. Even if Jason Lynch was a member of the household. Yeah. Requiring Jessica and Kenny to move but not otherwise changing anything about their household does not serve any legitimate end of government. There's no legitimate reason to prevent Bill from leasing the property. Other than we don't like poor people. Yeah. I like that, Andrew. It's not rent, they're just chipping in for the amenities. They're just chipping in, as the courtesy of their heart. And the amount of chipping just so happens to be the same amount as the amount I'd be renting to them. What are the odds? Normally, the law frowns on that kind of shell game, but here, I'd be sorely tempted to try it. Blah, 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 blah. All right. Fifth Amendment, taking clause. Yeah, taking of property, taking of the interest. And the liberty interest, not to put too fine a point on it. A leasehold is a property interest according to Illinois law. Yes, it is. They have an installment contract. The installment contract also gives them a greater equity stake than they would otherwise have. If they're successful, they would lose their equity stake. Okay? Because they would not terminate, but for the granite command to do so, there'd be sole cause of the destruction of the property interest. Acting under color of law, seeks to cause Jessica Kenny to be deprived of the interest without just compensations in violation of the takings clause. Yep. And it's taking a home, and as we all know from our Fourth Amendment law, the home is where the man is their castle, right? The home is the paramount property interest. It is the interest above all other interests. The home is special. Freedom of association. This argument won't win, but why not? Throw it in. Protects freedom of association. The only reason they're trying to force it out is that they're allowing Jason to stay there. I'll give you a quarter point for trying. Allowing a teenager to stay in your home and shelter him from the cold is a form of association. I'd also point out that it's a form of charity and basic Christian kindness, just to really, put in the needle if I could quote a couple lines from the Bible about taking care of the poor, or something that would be really on point, just to twist that needle in a little bit, I'd definitely throw that in there too. It's not strictly speaking legally relevant, but what the hell? It's my complaint. I'll put it in there if I want to. It's my party. I'll write it any way I want. Granite City's compulsory eviction law contains none of the procedural protections or substantive requirements found in any other legal tools. Yeah, Lord. How about we evict them, sell it to them, and then with loan terms that match the original rent? See, you're getting the idea. You're getting the idea. Well, there's all kinds of ways to circumvent this law. We could call it with all day long. Yeah, how about I sell it to you, and now I just have a mortgage with you. Um, I can give you a mortgage. A mortgage doesn't have to come from a bank. I mean, it traditionally does. But if I own the home, then if I own it, I can just give you a mortgage myself. Yeah, you have a mortgage now. Congratulations, you own the home. I'm the bank in this scenario. You can do that. Upon information belief, Granite City has no good reason and possesses no evidence suggesting it has a good reason for holding leasees strictly liable. Yeah, if you don't hold everyone strictly liable, what is your rationale? Oh, Lord. Prayer for relief. Plaintiff requests this court declare the compulsory eviction law, both on its face and as applied, violates the 14th Amendment, due process, equal protection, 5th Amendment, and right of association. Permanently permanently enjoin it. Award $1 nominal damages. Hey, that's a nice touch. That's a nice touch. You're just asking for nominal damages. I like that. That's a nice touch. That's very sort of big of you. And incidentally, $1 is the traditional amount of nominal damages. That's just traditionally the amount for nominal damages. So yeah, award us $1 of nominal damages. Sure, I like it. And another benefit of asking for nominal damages, incidentally, is there are certain issues at law that apply only if you're asking for money. So if you're not asking for money, there are certain things that don't trigger. So even though you're asking for literally $1, it's enough to get you those other benefits. So it's a really nice move from their lawyer to ask for those nominal damages, because it gets you a little extra cover than you wouldn't have otherwise. Award attorney's fees and such other relief brought by Samuel Gregg and Robert McNamara. We know that name from the Institute of Justice. So good for the Institute of Justice. Good for them. And then we have verification, sign on penalty of perjury, sign on penalty of perjury, sign on penalty of perjury. So this is a verified complaint in that the people have signed off saying that it's true. So, okay, great. That's fun, man. Wow. Yeah, as a city attorney, my advice would be, let's give up and let's not do this. That would be my recommendation. Uh, yeah, and then they would say no, and I'd probably have to go to court and figure out a way to defend this shit. So, being attorney sometimes means you have to do some really unpalatable things. So, someone worked hard all their life and became the city's attorney. And now the city's going to make them do this shit. Some days it does not pay to be an attorney. Because you have to go into court with a straight face and say, yeah, these people should be evicted. This law is the greatest thing ever. I can do it, but I don't want to. Is there a decision? No, probably not. I mean, it was just filed. There's probably not even a response yet. Yeah. Yeah, because this was just filed August 1st. Yeah, so this was just filed 24 days ago. So the response period isn't even due. There's not even a response yet. So no, there's no decision, unless the city immediately filed a we give up notice, which I'm betting didn't happen. So yeah, no response yet.